very warm welcome to Thorough Newspaper Analysis. Today is 19th of April and this video series is brought to you by LawSikho. Now see, as far as the agenda for today is concerned, at the very beginning, we're going to have an understanding of some of the important as well as relevant news updates in the segments of national and international news. These are essentially relevant in your exams where current affairs is a part of your syllabus. Now this is going to be followed by another segment where we take up important legal updates for the day. Today we have two such updates. And at the very end, we have an editorial-oriented segment where we develop an understanding of important socio-economic and social-legal concepts which are relevant for your exams and which are essentially relevant in order to develop critical thinking. Now the title for today's editorial is How Civil Union It is Different from Marriage. So essentially here we're going to have an understanding of what is the concept of civil union, secondly, how is it different from marriage, and thirdly, which all countries have adopted this concept of civil union in the past. Also, we're going to have an understanding of all of this in light of the ongoing hearing before the Honorable Supreme Court of the petitions that have sought legal recognition of a homosexual marriage. Now with this, let's dive into the DNA for today. So the first update, it is with respect to India getting the chair, India being the chair of, or getting to be the chair of Commonwealth Group on Reforms of Financial Architecture. So see, essentially during the Commonwealth Finance Ministers High-Level Working Group meeting, which is held in Washington, D.C., finance ministers from several Commonwealth nations, they have urged for a comprehensive overhaul of the global financial architecture. And this is being proposed in order to improve the availability of development financing to those countries which are in need and which are vulnerable. Now, how does this concern India? It concerns India because the ministers, they've agreed for India to be the chair and Nigeria to be the deputy chair of the group. Moving on, State Bank of India, it has reintroduced its retail term deposit scheme titled as Amrit Kalash. See, State Bank of India, which is India's largest lender by assets, it has announced the reintroduction of its retail term deposit scheme called Amrit Kalash. The scheme, it offers a special tenor of 400 days and it provides an interest rate of 7.6% for senior citizens and that of 7.1% for others. So see, essentially what happens is whenever we invest into any deposit scheme of some sort, so we do the investment as per our will, and the time period generally is not determined prior. So however, one of the features of this scheme is that the scheme already prescribes a period of 400 days. You have to invest for 400 days and following the this particular period, your deposits, they'll come to an end and then you're going to be in a position to retrieve your principal amount that you've invested along with the interest that you've procured as per the interest rate. And this scheme, it comes at a time when the banking system's deposit growth, it is lagging credit growth. It was introduced earlier this year as well. Now with this, we have come to another update, which is coming from the state of Andhra Pradesh. So the Andhra Pradesh government, it changes name of Greenfield Seaport in the district of Srikakulam. See, the government of Andhra Pradesh, it has renamed the Bhavnapadu port as Mulapeta port. This is done in order to respect the sentiments of the local villagers in the district of Srikakulam. The Chief Minister of the state, he is going to lay the foundation stone of the port today, that is on 19th of April. Moving on, this update is with respect to the launch of a scheme to promote tribal products from the Northeast states. So launching the marketing and logistics development for promotion of tribal products from the Northeast region, the Union Minister of Tribal Affairs, Shri Arjun Munda, he has said that through the Tribal Cooperative Marketing Development Federation, the scheme aims to empower individuals to become self-employed and self-reliant. Moving on to the international segment for today, the first update is coming from Syria. Syria has become the world's largest narco-state. See, according to reports, Syria has now become the world's largest narco-state with majority of its foreign currency, which is over 90% of the country's foreign currency earnings, coming from the production and export of Captagon, which is a highly addictive amphetamine commonly referred to as poor man's coke. Now, the next update is coming from Australia. So, Melbourne has surpassed Sydney as Australia's most populous city. Melbourne was earlier, it secured this particular title in the year 1905, and it has now regained this title in this year of 2023. Next update is coming from Kenya. Kenya launches its first operational satellite. The satellite, it is designed to gather environmental and agricultural data such as flood, drought, wildfire data, and this is going to enable, or this is going to be employed by authorities in order to manage disasters and tackle food security. The Falcon 9 rocket, which was delayed 3 times due to unfavorable weather conditions, it launched the Taifa 1 satellite from a base in California, and this was confirmed by SpaceX. Moving on to another update in the international segment itself, this is with respect to the observation of World Heritage Day on 18th of April. So World Heritage Day, which is also known as the International Monuments and Sites Day, it celebrates the work which is being carried out by the International Council on Monuments and Sites. The theme of this year's celebration is Heritage Changes. The council, it proposed the notion of observing World Heritage Day for the first time in the year 1982, and it was subsequently endorsed by the United Nations General Assembly the next year, which is in 83. Now, let's understand why the date of 18th April was chosen. This was selected to commemorate the adoption of Convention concerning the protection of world cultural and natural heritage by UNESCO in the year 1982. And this has brought us to the legal update segment for today. Now, before we proceed, I have a question. Which article of the Indian Constitution, I'm looking for a directive principle of state policy, which provides for the states to take affirmative actions or to secure a certain state or to stop the objects or places of historical or artistic importance from being destroyed or from getting spoiled. So kindly put down your answer in the comment section as to which article provides for the same. Now moving on, the first update is coming from the Honorable Supreme Court. The Supreme Court has held that commercial enterprises can raise consumer dispute in relation to goods and services unconnected to profit generation. The Honorable Apex Court has said that it is notable the Honorable Apex Court has held that an enterprise, it is not excluded from the definition of a consumer under the Consumer Protection Act of 1986 merely because it is a consumer exercise. A consumer enterprise too may raise their grievance regarding goods and services that were availed by the enterprise if the same was not for commercial purpose. The name of this particular case is National Insurance Company Limited versus Harsolia Motors and others. Another update is also coming from the Honorable Apex Court, which is held that Section 149 of the IPC, it is going to be attracted if 5 or more persons specifically named in the FIR are facing trial separately. So the Apex Court has observed that Section 149, which provides for unlawful assembly of the IPC, it shall be made applicable even if the specifically named 5 people constituting such an assembly, they have been named in an FIR and they're facing separate trials. So the name of this particular case is Surendra Singh versus State of Rajasthan and another. And this brought us to the editorial segment for today, which is indeed the most interesting one of this DNA. Now, see, the title of today's editorial is How Civil Union It is Different from Marriage. So essentially, अगर हम इसके आर्टिकल के फ्रेमवर्क की बात करें कि हम कैसे we're going to have an understanding of it, तो पहले तो we're going to understand the why of this article, which is the issue in this article, and यहाँ पर हम discuss करेंगे कि जो first day of hearing थी for the Honorable Apex Court with respect to these petitions seeking the legal recognition of a homosexual marriage, we're going to have an understanding as to what transpired yesterday before the Honorable Apex Court. This is going to be followed by an understanding of what is a civil union. फिर हम समझेंगे कि civil union और जो marriage का concept है generally understood, उन दोनों में difference क्या है, and then we're going to have an understanding of what other countries allow civil unions or they have allowed at certain point in time. and before eventually giving recognition to a homosexual marriage. Now let's understand the why of this article. So essentially yesterday was the first day of hearing before the Honorable Supreme Court, the Constitution Bench of the Apex Court, which consisted of Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, along with Justices Sanjay Kishan Kaul, Ravindra Bhatt, Justice Hema Kohli and Justice P.S. Narasimha. तो essentially हुआ क्या था before the bench or the central government or the state which was represented by the Solicitor General of India Tushar Mehta, उन्होंने pertinently argue ये किया था that these batch of petitions they are not maintainable itself, so let alone getting to the merits of these petitions. So on the issue of maintainability, he stated, and I quote, that when the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it and the another being against it. So in case of states not being joined, the petitions wouldn't be maintainable. The debate which is to happen to conferring or creation of socio-legal institution, should that be the forum for this court or for the parliament to decide? तो essentially उनका ये कहना था कि जो subject है which is creation of socio-legal relation of marriage, it falls within the domain of the parliament, so this is not a forum, the court is not the right forum to address it. And उनका ये भी कहना था कि implicate all the other states, because क्या है कि concurrent list का matter है, तो all the states should come on board. And also he argued against the maintainability of the petition. So while he was arguing, the Honorable Chief Justice of India, he was not inclined to dismissing the petition outrightly at the stage of maintainability itself. तो उन्होंने कहा कि let's just understand the canvas of this particular batch of petitions and then we can go about further proceedings. So in order to list out the framework or the canvas of the petitions, let's make a reference to what senior advocate Mukul Rohatgi had to say. So he said that I have a right to approach this court. I have a right to be heard. My grievance may be right or wrong. Your lordship will decide upon that. But we are persons who are of the same sex. We have, according to us, the same right under the Constitution of India as a heterosexual group of the society would have. Your lordship have already held that. The only stumbling block on our rights was Section 377 of the IPC, and now with that being gone, the criminality being gone, the unnatural part or the audit of nature is gone from our statute. So therefore our rights are equal. And he further stated that Article 32 itself is a fundamental right, which provides for the right to approach the court and seek constitutional remedies. So from this, the Supreme Court said that now that we've understood broadly the canvas of the matter, we can at this stage steer clear of personal laws, and it may not be necessary for the court to then get into the personal law. तो essentially कोर्ट का कल की जो हियरिंग का अगर हम देखें तो ये था कि कोर्ट अभी फॉर द टाइम बीइंग इज गोइंग टू बी रेस्ट्रिक्टेड विद रिस्पेक्ट टू द इंटरप्ले ऑफ सेम सेक्स मैरिज or the Special Marriage Act. Court is not going to venture into the realm of the personal laws. I'm sorry. Councils time and again they brought the concept of this particular argument of the interplay of personal laws, but the court outrightly rejected it, and it said that for the time being, this is going to be the scope of our proceedings. Now let's understand the article. So see, while the centre, through Solicitor General Tushar Mehta, he contested the maintainability of the petitions and the judiciary's right to confer legal recognition on the socio-legal institution of marriage, the Chief Justice observed that the court's hearing scope, it would be limited to developing a notion of civil union that finds legal recognition under the Special Marriage Act. Now let's understand what is a civil union. देखिए civil union essentially refer करता है to legal status that allows same-sex couples specific rights and responsibilities which are normally conferred upon a married couple. And although it resembles marriage and it brings with it certain rights, जैसे कि employment to a spouse, then inheritance, property and paternal and coupled with other rights, but there is a certain difference between these two. And इस difference को समझने के लिए हमें जाना पड़ेगा to a decision of the US Supreme Court. So in the year 2015, the United States Supreme Court, it legalized same-sex marriage across the nation with its landmark ruling in the case of Obergefell versus Hodges. सो प्रायर टू 2015 अगर हम पोजीशन देखें तो वहाँ पे क्या था, कुछ जो स्टेट्स थे उन्होंने सिविल यूनियन के कॉन्सेप्ट को अडॉप्ट कर रखा था एंड कुछ स्टेट्स ने नहीं कर रखा था. सो प्रायर टू 2015 रूलिंग, द मेजॉरिटी ऑफ यूएस स्टेट्स दे हैड सिविल यूनियन लॉज that allowed same-sex couples to marry without providing formal recognition to the same. And these unions, they would be accompanied by certain rights as well. And वो rights क्या क्या थे? Inheritance के right, employment benefits to spouse, then joint parenting और joint ownership, and also एक और right था वहाँ पे जो कि हमारे Indian Evidence Act में भी है, which is privilege communication. And this is my question to you: which section of the Indian Evidence Act provides for protection to a spouse from testifying with respect to any communication which was disclosed by the partner of the person concerned, who is being forced to testify or who is willing to testify and is seeking permission. So कौन सा ऐसा सेक्शन है इंडियन एविडेंस एक्ट का जो कहता है, जो प्रोटेक्शन देता है, you will not be forced to testify any communication which was made to you by your spouse during the continuation of your marriage? Kindly put down your answers in the comment section. So now see, a big difference between civil unions and marriage, it was that the former was recognized solely by issuing states and it was not a federal law. Now this created a situation जहाँ पे क्या हुआ था कि कुछ couples जो कि जिस states में ये recognize था वहाँ पे they got certain rights by virtue of such recognition, but these rights were snatched away when other states where this recognition was not given. तो इससे क्या हो गया, कुछ disparity cause हो गई. Now in the wake of the legislation of same-sex marriages, several unions, they were converted eventually into marriages. Now let's understand कि कौन सी और कंट्रीज थी जिन्होंने सिविल यूनियंस को अलाउ करा था. तो देखिए, यूनाइटेड स्टेट इज वन ऑफ द कंट्रीज दैट अलाउ सेम सेक्स मैरिजेस. एंड देन अगर हम बात करें स्वीडन की, तो इट लीगलाइज्ड सेम सेक्स मैरिज इन and LGBTQ couples that they could apply for civil unions and enjoy benefits such as right to adopt. Similarly, अगर हम बात करें नॉर्वेन couples की, तो in the year 1993 couples in Norway, they enjoyed the right to enter into civil unions, which gave way to a new law 15 years later, जहाँ पे उन्होंने allow कर दिया such couples to marry, to adopt and to undergo artificial insemination, जो कि which are sponsored by the state. And then we come to Austria. So वहाँ पे भी same-sex couples, they could form civil partnerships between the years 2010 and 17. However, this changed with the Supreme Court ruling that deemed civil unions discriminatory in the year in 2019 when such marriages were legalized. उसके अलावा कुछ और countries हैं, including Brazil, they have also accepted the legal standpoint of civil unions between LGBTQ plus couples. So with this, we have come to an end for today's TNA. In case you want to get access to the free study material that we provide and to the TNA slides, please feel free to join our Telegram channel using the link which is provided in the description, or you may scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Also, the link for the quiz, which is based out of yesterday's TNA, it is made available in the description of today's video. Kindly go through the same, and I would encourage all of you to attempt the same. And put down your answers in the comment section, and please like, share and subscribe to our channel for more such updates. Thank you for being with us. And this has brought us to the last segment and the most interesting, which is the editorial segment. The title for today's editorial is How Civil Union It is Different from Marriage. Now this is going to be our structure of understanding this article. At the very outset, we're going to have an understanding the why of it. यहाँ पर हम briefly समझेंगे कि what all transpired before the Honorable Apex Court yesterday, जब first day of hearing was observed in the batch of petitions seeking legal recognition to homosexual marriage. उसके बाद we're going to have an understanding of the concept of civil union, and फिर हम समझेंगे कि कैसे different है marriage से, and then we're going to understand how different countries have adopted the concept of civil union at different points in time before they moved on to recognizing homosexual marriage. So with this, let's start with the editorial today. So देखिए, yesterday the hearing began before a constitution bench of 5 judges, which comprised Honorable the Chief Justice of India, Dr. D.Y. Chandrachud, and Justices Sanjay Kishan Kaul, Ravindra Bhatt, Hima Kohli, and P.S. Narasimha. अभी इस पूरे जो कल की हियरिंग थी उसका अगर हम क्रक्स देखें कि व्हाट हैपेंड और व्हाट ऑल ट्रांसपायर्ड, सो वी वुड सी दैट द सॉलिसिटर जनरल फॉर इंडिया तुषार मेहता, उन्होंने काफ़ी assertively आर्ग्यू किया. ही आर्ग्यूड द मेंटेनेबिलिटी ऑफ द पेटिशंस इटसेल्फ, और उनका ब्रॉडली ये कहना था, पहला तो मेंटेनेबिलिटी को उन्होंने चैलेंज किया और दूसरा उनका ब्रॉडली ये कहना था कि the entire the subject of creation of socio-legal relation of marriage, it falls within the domain of the legislature, so why the courts should come in. And he also stated that all the states should also be implemented to these petitions, so that whatever is arrived at, or whatever is now the conclusion is going to be, so all the states are made parties. Now I'm going to quote what he argued, one of what he said during the proceedings, so that we get a clear picture. So he said that and I quote, when the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it and another state being against it. Now, in cases of states not being joined, the petitions wouldn't be maintainable. The debate which is to happen or to conferring or creation of socio-legal institution, should that be the forum for this court or the parliament to decide? So this is essentially what he said. Now to this, the Chief Justice of India, he stated, or he showed his disinclination for dismissing the petition outrightly at the stage of maintainability or on the claim of maintainability. तो उन्होंने कहा कि let's just understand first कि what is going to be the canvas of this entire petition, कि जो petitioners हैं उनके broadly arguments क्या होंगे, ताकि हम एक कैनवस प्रिपेयर कर सके, एक फ्रेमवर्क प्रिपेयर कर सके, and then we can go about it. So for this, senior advocate Mukul Rohatgi, he said, he contended, and I quote, that I have a right to approach this court. I have a right to be heard. My grievance may be right or wrong. Your lordships will decide upon that. But we as persons who are of, who are of same sex, we have, according to us, the same rights under the Constitution as the heterosexual persons or group of the society has. Your lordships have held that. The only stumbling block on our right, it was section 377 of the IPC, and that is now gone. The criminality is now gone. The unnatural part or order of nature is gone from our statute. So therefore, our rights are equal. He further added that the right to approach the Supreme Court under Article 32, it itself is a fundamental right. So now with this, the Honorable Chief Justice, he stated that now we've understood broadly the canvas of the matter, and we can at this stage, at this particular stage, we can steer clear of personal laws, and it may not be necessary for the court to then get into personal laws, unquote. So essentially court का ये कहना था कि जो अगर हम क्रक्स देखें ना कि कल की हियरिंग का क्या, तो वो ये था कि as of this moment, as of now, petitions को पूरा हम deal in करेंगे with respect to Special Marriage Act, and we're not going to dive into the personal laws. And काफी सारे जो councils हैं और government council हैं, otherwise also they kept on bringing the matter back to personal laws, और उन्होंने कहा कि personal laws को हम we cannot go about it, we cannot deviate it, we have to address the personal law element. However, the court categorically stated that as of this moment, for now, we're going to venture into the entire realm of validity of homosexual marriage with respect to Special Marriage Act. So see, while the centre, through Solicitor General Tushar Mehta, it contested the maintainability of the petitions and the judiciary's right to confer legal recognition on the socio-legal institution of marriage, the CJI observed that the hearing scope, it would be limited to developing a notion of civil union that finds legal recognition under the Special Marriage Act. Now let's understand what essentially is a concept of civil union. तो देखिए, सिविल यूनियन जो है, इट रेफर्स टू द लीगल स्टेटस दैट अलाउज अ होमोसेक्सुअल कपल स्पेसिफिक राइट्स एंड रिस्पॉन्सिबिलिटीज जो कि नॉर्मली एक हेट्रोसेक्सुअल कपल के पास होते हैं. Although a civil union, it resembles marriage and it brings with it employment, inheritance, property and paternal rights, there are some differences as well between the two. So अगर हम differences की बात करें तो यहाँ पे we're going to understand the case of the legal framework in the state of in US. So see, in the year 2015, the US Supreme Court, or the Supreme Court of the United States, it legalized homosexual marriages across the nation with its landmark ruling of Obergefell and versus Hodges. So prior to the 2015 ruling, the majority of the US states, it had civil union laws that allowed same-sex couples to marry without providing formal recognition to the same. तो हुआ क्या था कि prior to 2015 जो US के certain states थे, they had civil union laws that had recognized same-sex marriages without the same being turned into a federal law. However, उसके बाद क्या हुआ कि since this ruling came into picture, so all the states they were now to give legal recognition because of the ruling, so it became law. Now, these civil unions, they would be accompanied by rights such as your inheritance right, employment benefit to spouses, joint parenting or joint ownership rights, and the right to abstain from testifying against one's partner. जैसा कि हमारे पास इसका parallel provision Indian Evidence Act में भी है under section 122 of the Indian Evidence Act, which protects a spouse from testifying with respect to any communication which is made to the person concerned by his or her spouse during the continuation of marriage. So that is one of the protection that is available to a married couple in India, and the same was also made available here. Now see a big difference as far as these two concepts is concerned, which is the norm of marriage that we understand and the concept of civil union. It is that the former, which is civil union, it was recognized solely by issuing states and not by federal law, because there were certain states which recognized this, but it was not a federal law. So this was one of the difference. Now this created a situation where such couples would enjoy the benefits of being in a civil union uniformly across all states. They were not able to do so. So since the US has a state system where the states, they determine on their own marriage laws, so this disparity of recognition, it existed. तो essentially हुआ क्या था कि since it was not a federal law, so uniformly ये practice नहीं थी. So certain states where this particular union was recognized, there were certain rights which accrue to a couple by virtue of such recognition. However, this benefit or this right did not continue to those states which did not give such recognition. So there is this disparity which existed. Now, in the wake of the legalization of homosexual marriages, several unions, they were converted into eventually marriages. Now let's understand what all countries they had this concept early on also. So the United States, in just one of the countries, it is one of the countries that allows a same-sex union. And before the year 2009, which is the year that Sweden legalized homosexual marriages, LGBTQ couples, they could apply for civil unions and enjoy benefits such as the right to adopt. Similarly, we have Norway. It has been enjoying the right of civil union for gay couples since the year 1993. And also civil marriages it was also prevalent in Austria from the year 2010, before the same was turned into law in the year 2019 in January. And apart from that, we have other countries including Brazil, which have accepted the legal standpoint of civil unions between LGBTQ plus couples. So with this, we've come to the end for today's TNA. In case you want to get access to the free study materials and the TNA slides which have been used in this particular video, please feel free to join our Telegram channel using the link in the description, or you may scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho for any purpose. Also, the link for yesterday's TNA-based quiz, it is attached to today's video's description. Kindly go ahead and attempt the same. I would encourage all of you to do so. Also put down your answer in the comment section for the question that was posed in today's video. And thank you for being with us.